Basic medical expense plans. Basic medical expense insurance is sometimes called first-dollar insurance. Unlike major medical expense insurance, it provides benefits upfront without having to satisfy a deductible. Basic medical expense policies classify their coverages according to general categories of medical care, hospital expense, surgical expense, and physician's non-surgical expense. Basic medical expense insurance typically has lower benefit limits than major medical insurance. The benefits provided by basic medical expense insurance are lower than the actual expenses incurred. A particular fee charged by a physician or other health professional is called a usual, customary, and reasonable expense. The amount of the patient's claim payment will be based on the terms of the policy. Hospital expense policies cover hospital room and board, miscellaneous hospital expenses such as lab and X-ray charges, medicines, use of operating room, and supplies. These expenses are covered while the insured is confined in a hospital. There is no deductible and the limits on room and board are set at a specified dollar amount per day up to a maximum number of days. Hospital room and board benefits cover expenses for occupancy of the room and bed, general nursing care, food and beverages, and personal hygiene items. Concurrent review is a method of utilization review that takes place on site when a patient is confined to a hospital. A typical result of a concurrent review is that the length of stay in the hospital is monitored. Pre-admission testing helps control healthcare costs primarily by reducing the length of hospitalization. These limits may not provide for the full amount of hospital room and board charges incurred by the insured. For example, if the hospital expense benefit was $200 per day and the hospital actually charged $400 per day, the insured would be responsible for the additional $200 per day basic surgical expense coverage, commonly written in conjunction with hospital expense policies. These policies pay for the costs of surgeon's services, whether the surgery is performed in or out of the hospital. Coverage includes surgeon's fees, anesthesiologist, and the operating room. Under the surgical schedule approach, every surgical procedure is assigned a dollar amount by the insurer. Under the reasonable and customary approach, the surgical expense is compared to what is deemed reasonable and customary for the geographical part of the country where the surgery was performed. If the charge is within the reasonable and customary parameters, the expense is normally paid in full. If the charge is more than what is reasonable and customary, the patient must absorb the difference. Usual, customary, and reasonable charges are the maximum amount the insurer will consider eligible for reimbursement under a health insurance plan. It is based primarily on average charges within the geographic area 34. The relative value approach is similar to the surgical schedule method. The difference is that instead of a flat dollar amount being assigned to every surgical procedure, a specified set of units is assigned. The policy will carry a stated dollar per units amount known as the conversion factor to determine the benefit. Basic physician's expense coverage, often referred to as basic physician's non-surgical expense coverage because it provides coverage for non-surgical services a physician provides. Basic medical expense coverage can be purchased to cover emergency accident benefits, maternity benefits, mental and nervous disorders, hospice care, home health care, outpatient care, and nurses' expenses. Regardless of what type of plan or coverage is purchased, these policies usually offer only limited benefits that are subject to time limitations. Physician assistance. No agency, institution or physician providing a service for which payment or reimbursement is required to be made under a policy governed by state law shall be denied such payment or reimbursement on account of the fact that such services were rendered through a physician assistant. Other basic plans. Nurses' expense benefits usually pay only for private duty nursing care arranged according to a doctor's order while the insured is a hospital patient. Both registered professional and licensed practical nurses may be covered. Convalescent care facility benefits provide a daily benefit for confinement in a skilled nursing facility for a limited recovery period following discharge from a hospital. Pharmacy benefits. Patient care services are generally limited to medication dispensing and medication therapy management activities required by individual state boards of pharmacy. A controlled substance list is a pharmacy benefit that covers prescription drugs. Major medical expense plans. Major medical expense insurance usually picks up where basic medical expense insurance leaves off in one of two ways, as a supplement to a basic plan or as a comprehensive standalone plan. Major medical expense plans offer broad coverage under one policy. 35. Benefit periods are generally for 1 year. Benefits for reasonable and necessary medical expenses, subject to policy limits. Comprehensive coverage for hospital expenses, room and board and miscellaneous expenses, nursing services, physician's services, etc. Catastrophic medical expense protection. Benefits for prolonged injury or illness. Unlike the basic medical expense plans, these policies usually carry deductibles, coinsurance requirements, and have large benefit maximums. Coverage is provided for both inpatient and outpatient hospital expenses. Hospice benefits under a major medical plan normally includes coverage for pain management, home-based services, and counseling. The list of prescription drugs covered by a pharmacy benefit is called a drug formulary supplementary major medical. These policies are used to supplement the coverage payable under a basic medical expense policy. After the basic policy pays, the supplemental major medical will provide coverage for expenses that were not covered by the basic policy, and expenses that exceed the maximum. If the time limitation is used up in the basic policy, the supplemental coverage will provide coverage thereafter. Comprehensive major medical combines the features of basic expense coverage and major medical coverage, sold as one policy. Cover practically all medical expenses, hospital, physicians, surgical, nursing, drugs, laboratory tests, etc. Comprehensive major medical policies include a deductible, usually a single deductible per person and per family, but corridor deductible may also apply, coinsurance, and are generally sold on a group basis. An example of a comprehensive health policy is a major medical policy. Most major medical plans contain a lifetime maximum benefit that limits the insurer's total exposure under a contract, while few contain a per-cause maximum benefit which limits the medical expenses covered for each cause. More expensive plans are characterized by an unlimited lifetime limit restoration of used benefits. Major medical policies that have a lifetime maximum benefit or a per-year maximum will always have the possibility that the limit could be exhausted. This provision allows the maximum benefit to be restored after a specific amount of the benefit is used or after the plan has been in effect for a specified period of time. The amount of coverage restored is usually a percentage of the used benefit. Major medical expense characteristics. Deductible. A deductible is a stated initial dollar amount that the individual insured is required to pay before insurance benefits are paid. Deductibles are used primarily to help control the cost of premiums and are used most frequently with major medical policies. A policy can have multiple types of deductibles. 36. Flat initial deductible is a stated dollar amount that applies to a covered loss, for example $500. This deductible is applied per occurrence, per insured individual. Corridor deductible covers the gap between basic coverage and major medical. When a major medical policy is supplementing basic coverage that contains no deductible, the deductible is not applied until the basic coverage has been exhausted. Integrated deductible is used when a major medical plan is supplementing basic coverages. For example, if the major medical has a $500 deductible and the insured has basic coverage of $500 or more, then, in the event of a claim, the amount paid by the basic coverage satisfies the major medical deductible. However, if the basic does not cover the entire deductible amount of the major medical plan, the insured is required to make up the difference. In a per-cause deductible, the insured must satisfy a deductible for each accident or illness. In an all-cause deductible, the insured only has to meet the deductible amount once during the benefit period. With a calendar year deductible, the deductible year begins on January 1st and ends on December 31st. Calendar year deductibles reset every January 1st. A calendar year deductible requires the insured to pay a specific sum out of pocket before any benefits are paid in a calendar year. The carryover provision permits expenses incurred during the last 3 months of the calendar year to be carried over into the new year if needed to satisfy the deductible for the next year. Common accident or sickness deductible. Some major medical plans include a common accident or sickness provision which states that only one deductible, usually equal to the individual deductible amount, need be satisfied when 2 or more insureds from the same family are injured in the same accident or suffer concurrently from the same illness. Family maximum deductible. Family maximum deductible waives the deductible for all family members after some of them have satisfied individual deductibles within the same year. Once a family deductible is satisfied, future covered medical expenses of all family members are paid just as if each member of the family had satisfied his or her individual deductible. Co-insurance. Co-insurance is another characteristic of major medical policies. It is a sharing of expenses by the insured and the insurer. After the insured satisfies the deductible, the insurance company and the insured share in the remainder of expenses. The insurance company pays a high percentage of the additional expenses, usually 75% or 80%, and the insured pays the remainder. Typically, the percentage of payment participation required of the insured is 20%, and the insurance company pays 80%. Co-insurance requires the insured to participate in the payment of expenses. Stop loss, out-of-pocket, maximum out-of-pocket. Stop loss is a feature designed to limit the amount of expense the insured may be exposed to in a policy year. Often, the stop loss will state that after the insured has paid a specific amount toward his covered expense, the insurer will pay 100% of the remaining expenses for the remainder of the policy year, up to the maximum limit of the policy. 37. Pre-existing conditions. Most policies contain a benefit limitation on pre-existing conditions. Limitations apply to all pre-existing conditions whether or not the insured declared them on the application. Unlike the impairment rider, the exclusion for pre-existing conditions is subject to the time limit for certain defenses. When considering the replacement of an individual accident and health insurance policy, a pre-existing conditions exclusion in the new contract may reduce the insured's benefits. The new policy may not cover the same health conditions under the new policy. Internal limits. Certain types of expenses may have limits placed on the dollar amount of certain services or on the type of service provided. For example, the policy will only pay for a semi-private room, not for a private room. Or it will pay only medical expenses that are usual and customary. Or it will pay lifetime alcohol or drug rehab expenses only up to $10,000, or for 75 days, etc. Medical expense accounts. Health savings accounts, HSA. A tax-advantaged medical savings account available to individuals who are enrolled in a high-deductible health plan. The funds contributed to an account are not subject to federal income tax at the time of deposit and roll over and accumulate year to year if not spent. HSAs are owned by the individual and are an alternate tax-deductible source of funds used to pay for qualified medical expenses at any time without federal tax liability or penalty. Health savings accounts, HSAs, are designed to help individuals save for qualified health expenses such as deductibles, co-insurance, prescription drugs, etc. that they, their spouse, or their dependents incur. HSAs are tax-deductible. An individual who is covered by a high-deductible health plan can make a tax-deductible contribution to an HSA and use it to pay for out-of-pocket medical expenses. Contributions to HSAs by individuals are deductible, even if the taxpayer does not itemize. Contributions by an employer are not included in the individual's taxable income. To be eligible for a health savings account, an individual must be covered by a high-deductible health plan, HDHP. Must not be covered by other health insurance, does not apply to accident insurance, disability, dental care, vision care, long-term care, must not be eligible for Medicare, and can't be claimed as a dependent on someone else's tax return. Distributions other than for qualified medical expenses to a health savings account are taxable and subject to a penalty of 20%. Health reimbursement arrangements must be established by the employer. Employer-funded, tax-advantaged health benefit plans that reimburse employees for out-of-pocket medical expenses and individual health insurance premiums. Unused amounts may be carried forward for reimbursement in future years. Reimbursements may be tax-free if the employee paid for qualified medical expenses or a qualified medical plan. Employee does not contribute to NR 38 medical savings accounts, MSA, created to help employees of small employers, as well as self-employed individuals, pay for their medical care expenses. MSAs are tax-free accounts set up with financial institutions such as banks and insurance companies. Qualified medical savings accounts are available for employers with no more than 50 employees. Flexible savings accounts, flexible spending accounts. Tax-advantaged accounts that can be set up through a cafeteria plan of an employer. EFSA allows an employee to set aside a portion of earnings to pay for qualified medical expenses, such as prescription medication, as established in the cafeteria plan. 39 private insurance plans for seniors. Medicare supplements, Medicare Select, Medicare Part C and D, Medicare supplement policies, Medigap. Medicare Supplement, Medigap, insurance is specifically designed for individuals by the age of 65 who have enrolled in Medicare. However, anyone currently receiving Medicare Parts A and B is eligible to participate in a Medigap policy. Medicare and hospital deductible is addressed with Medicare Supplemental Insurance. A Medigap policy is a Medicare supplement insurance policy sold by private insurance companies to cover medical costs not covered by the government in Medicare Parts A and B. Medigap policies do not pay costs for Medicare Parts C and D. As of June 2010, there are 10 standardized Medigap plans. Each of the 10 plans has a letter designation of A, B, C, D, F, G, K, L, M, or N. These policies were standardized by the National Association of Insurance Commissioners (NAIC) to help consumers understand and compare them and make informed buying decisions. These standards can be found in NAIC's Medicare Supplement Insurance Minimum Standards Model Act. Medicare supplement policies sometimes provide preventative medical care benefits such as annual physical exams. A Medicare supplement policy must not contain benefits which duplicate Medicare benefits. Individuals over 65 who have just enrolled in Medicare Part B for the first time cannot be refused a Medicare supplement policy and cannot be rated if they apply for coverage within 6 months of Part B enrollment. In other words, Medicare supplements must be guaranteed issue during open enrollment. All Medicare supplement policies must be guaranteed renewable and can only be cancelled by the insurer for non-payment of premiums. Hospice care is included in most standard Medicare supplement insurance policies. Hospice care typically offers a family counseling benefit. Medicare supplement policies typically provide foreign travel emergency healthcare coverage as a core benefit when you travel outside the U.S. Coverage for Medicare Part B excess charges is a Medicare supplement additional benefit. Medicare Supplement Plan F will not pay for charges exceeding the approved amount. In general, the following 6 minimum standards apply to all policies designated as Medicare Supplement Insurance. O. The policy must supplement both Part A and Part B of Medicare. O. The policy must automatically adjust its benefits to reflect statutory changes in Medicare. O. The policy must cover all expenses not covered by Part A from the 61st to the 90th day. Furthermore, it must cover the lifetime reserve copayment and must provide full coverage for an additional 365 days after Medicare benefits are exhausted. If the policy excludes coverage for pre-existing conditions, the exclusion cannot exist for longer than 6 months. That is, no coverage can be denied as a pre-existing condition after the policy has been in effect for 6 months. Part B expenses not covered by Medicare, that is, the 20% copayment, must be covered by the Medigap policy. However, policies may include a deductible before this benefit becomes payable. The policy must include a minimum 30-day free look provision. 40 core benefits. All Medicare supplement plans cover co-insurance on hospital costs, up to an additional 365 days after Medicare Part A hospital benefits run out. All Medigap policies also cover at least part of these costs. Medicare Part A hospice co-insurance or copayment. Medicare Part B co-insurance or copayment. First 3 pints of blood received as a hospital inpatient. Medicare Select. Medicare Select coverage means Medicare supplement coverage through a preferred provider organization, PO, or any other type of restricted network whose coverage has been approved by the state. A PO is a healthcare provider or an entity that contracts with healthcare providers that establish alternative or discounted rates of payment and offers the insured certain advantages for selecting the member providers. Examples of Medicare Select organizations include provider groups, hospital marketing plans, and groups that are formed or operated by insurers or third-party administrators. An insured must choose providers that belong to a network, except in cases of emergencies. With a Medicare Select plan, the insured agrees to use preferred providers, and in exchange, pay a lower premium. Medicare and managed care. There are a number of managed care organizations (MECOS) that have contracted with the Healthcare Financing Administration to provide both Part A and Part B services to Medicare recipients. Medicare managed care plans are offered by private companies. A company can make a plan available to everyone with Medicare in a state or only be open in certain counties. A company also may choose to offer more than one plan in an area, providing different benefits and costs. Each year a managed care company can decide to join or leave Medicare. Medicare Part C. Medicare Advantage. Medicare Advantage plans are Medicare provided by an approved health maintenance organization or preferred provider organization. Some of these plans do not charge premiums beyond what is paid by Medicare and others do. These are coordinated care plans that generally offer people with Medicare additional benefits and coordinated care beyond the standard Medicare coverage, such as eye exams, hearing aids, dental care, and prescription drugs. Another choice is a private fee-for-service (PFFS) plan. In this type of plan, an individual may go to any Medicare-approved doctor or hospital that accepts Medicare payments. The insurance plan, rather than the Medicare program, decides how much it will pay and what the Medicare enrollee pays for the services rendered. The plan could include extra benefits that are not covered under the original Medicare plan. HMOs, POs, and private fee-for-services are all types of a Medicare Advantage plan. In addition to the premium, Medicare Advantage enrollees normally must pay a small copayment per visit or per service. Medicare Part C does not cover long-term care. 41 Medicare Part D is a prescription drug plan administered by one of several private insurance companies, each offering a plan with different costs and lists of drugs that are covered. Participation in Part D requires payment of a premium and a deductible. Long-term care insurance and nursing home care is often covered by long-term care insurance. However, long-term care (LTC) refers to a broad range of medical, personal, and environmental services designed to assist individuals who have lost their ability to remain completely independent in the community. Although care may be provided for short periods of time while a patient is recuperating from an accident or illness, LTC refers to care provided for an extended period of time, normally more than 90 days. Depending on the severity of the impairment, assistance may be given at home, at an adult care center, or in a nursing home. It is similar to most insurance plans in that the insured receives specified benefits in the event long-term care is required. Most LTC policies pay the insured a fixed dollar amount for each day the policy covers, regardless of what the care costs. Long-term care coverages. As individuals age, they are likely to suffer from acute and chronic illnesses or conditions. An acute illness is a serious condition, such as pneumonia or influenza, from which the body can fully recover with proper medical attention. The patient may also need some assistance with chores for short periods of time until recovery and rehabilitation from the illness are complete. Some people will suffer from chronic conditions, such as arthritis, heart disease, or hypertension, which are treatable but not curable illnesses. Over time, a chronic condition frequently goes beyond being a nuisance and begins to inhibit a person's independence. Most long-term care insurance policies will pay benefits when you cannot perform at least 2 activities of daily living (ADL). The activities of daily living are a series of basic activities performed by individuals on a daily basis necessary for independent living at home or in the community. There are many variations on the definition of the activities of daily living, but most organizations agree there are 5 basic categories. 1. Personal hygiene: bathing, grooming and oral care. 2. Dressing: the ability to make appropriate clothing decisions and physically dress oneself. 3. Eating: the ability to feed oneself though not necessarily to prepare food. 4. Maintaining continence: both the mental and physical ability to use a restroom. 5. Transferring: moving oneself from seated to standing and get in and out of. Categories of long-term care. Skilled nursing care is continuous, around-the-clock care provided by licensed medical professionals under the direct supervision of a physician. Skilled nursing care is usually administered in nursing 42 homes. Intermediate nursing care is provided by registered nurses, licensed practical nurses, and nurses' aides under the supervision of a physician. It's provided in nursing homes for stable medical conditions that require daily, but not 24-hour, supervision. Custodial care provides assistance in meeting daily living requirements, such as bathing, dressing, getting out of bed, toileting, and so on. Home and community-based services: home health care is care provided in the insured's home, usually on a part-time basis. It can include skilled care, for example, nursing, rehabilitative, or physical therapy care ordered by a doctor, or unskilled care, for example, Help with cooking or cleaning. Adult daycare. Adult daycare is designed for those who require assistance with various activities of daily living, while their primary caregivers, usually family or friends, are absent. Respite care. Respite care is designed to provide a short rest period for a family caregiver. Continuing care. Designed to provide a benefit for elderly individuals who live in a continuing care retirement community. Taxation of LTC benefits. Qualified LTC insurance contracts are treated in the same manner as accident and health insurance contracts. Amounts received under an LTC contract are excluded from income because they are considered amounts received for personal injuries and sickness. There is a limit on these amounts, and these limits are adjusted for inflation annually. Long-Term Care Partnership Plan. The Long-Term Care Partnership Program is a federally supported, state-operated initiative that allows individuals who purchase a qualified long-term care insurance policy or coverage to protect a portion of their assets that they would typically need to spend down prior to qualifying for Medicaid coverage. The difference between a long-term care partnership plan and a non-partnership plan is asset protection. 43. Proposed Social Security. The Social Security system provides a basic floor of protection to all working Americans against the financial problems brought on by death, disability, and aging. Social Security augments, but does not replace a sound personal insurance plan. Unfortunately, too many Americans have come to expect Social Security will fulfill all their financial needs. The consequence of this misunderstanding has been disillusionment by many who found, often too late, they were inadequately covered when they needed life insurance, disability income, or retirement income. Social Security, also known as old age, survivors, and disability insurance (OASD), was signed into law in 1935 by President Roosevelt as part of the Social Security Act. Social Security was established during the Great Depression to assist the masses of people who could not afford to sustain their way of life because of unemployment, disability, illness, old age, or death. WHO has covered. Social Security extends coverage to virtually every American who is employed or self-employed, with few exceptions. Those not covered include most federal employees hired before 1984 who are covered by civil service retirement or another similar plan. Approximately 25% of state and local government employees who are covered by a state pension program and elect not to participate in the Social Security program. Railroad workers covered under a separate federal program called the Railroad Retirement System. How benefits are determined. A person must be insured under the Social Security program for survivors, disability, or retirement benefits to pay. Social Security benefits are based on how long a covered worker has worked throughout his life. Insured status. Social Security establishes benefit eligibility based on an insured status. There are two types of insured statuses that qualify individuals for Social Security benefits. To obtain fully insured status, a covered worker must accrue a total of 40 quarters of credit, which is about 10 years of work. To be considered currently insured, and thus eligible for limited survivor benefits, a worker must have earned 6 credits during the last 13-quarter period. Social Security payroll taxes. Funding for Social Security is collected from FICA payroll taxes. Social Security payroll taxes are collected from employers, employees, and self-employed individuals. FICA tax is applied to an employee's income up to a certain income amount. This amount is called the taxable wage base. There is a maximum amount of earnings that can be subject to Social Security tax each year. This amount is indexed each year to the National Average Wage Index. This maximum applies to employers, employees, and self-employed individuals. Medicare Part A taxes are not subject to a maximum taxable wage cap. 44. Taxation of Social Security benefits. Social Security benefits are subject to federal income tax if the beneficiary files an individual tax return and his annual income is greater than $25,000. Joint filers will pay federal income tax on their Social Security benefits if their income is greater than $32,000. Calculating benefits. Based on the individual's average monthly wage during his working years. The primary insurance amount (PIA) is used to establish the benefit. It is equal to the worker's full retirement benefit at age 65. If a worker retires early, for example at age 62, his retirement benefits will be 80% of his PIA and will remain lower for the covered worker's life. The PIA is based on the average earnings over your lifetime. Types of OASD benefits: survivor's benefits, Social Security survivor's benefits or death benefits, pay a lump sum death benefit or monthly income to survivors of deceased covered workers. Survivor's benefits include a $255 lump sum death benefit, surviving spouse benefits, child's benefit, and parent's benefit. A surviving spouse without dependent children is eligible for Social Security survivor benefits as early as age 60. Survivor benefits are also available to a spouse of any age who is caring for children under age 16, children under age 18, children under age 19 who are full-time students, children at any age if disabled before age 22 and remain disabled. A Social Security benefit of 75% of the primary insurance amount (PIA) is given to an underage child of a deceased worker. Disability benefits only available to covered workers who are fully insured, as defined by Social Security, at the time of disability. Disability income benefits are paid to the covered worker in the amount of the PIA after a 5-month waiting period. Only available prior to the age of 65. Does not pay partial disability or short-term disability benefits. Disability must be total and expected to last 12 months or end in death. Benefits include monthly payments to the disabled worker, spousal benefits, and child's benefits. Definition of disability: in order to be considered totally disabled, an individual has to qualify according to the following requirements: the inability to engage in any gainful work that exists in the national economy, the disability must result from a medically determinable physical or mental impairment that is expected to result in early death, or has lasted, or is expected to last for a continuous period of 12 months. 45 Retirement benefits. Benefits are only available to covered workers who are fully insured upon retirement. Benefits are paid monthly. If a covered worker retires at the normal retirement age, he will receive 100% of the PIA. If a covered worker retires early at the age of 62, the maximum Social Security benefit is 80% of the PIA. This reduction remains all through retirement. Retirement benefits pay covered retired workers at least 62 years of age, their spouses and other eligible dependents' monthly retirement income. Retirement benefits include monthly retirement payments to the covered worker, spousal benefits, and child's benefits. Blackout period. Benefits paid to the surviving spouse of a deceased person who was receiving Social Security. The blackout period begins when Social Security survivorship benefits cease. This is when the youngest child turns 16 years old, or immediately if there are no children. The blackout period ends when the surviving spouse turns at least 60 years old. 46 Health insurance policy provisions, riders, and exclusions. NAIC Model Health Insurance Policy Provisions. Years ago, the National Association of Insurance Commissioners (NAIC) developed a Model Uniform Individual Accident and Sickness Policy Provisions Law. Almost all states have adopted this model law or similar legislation or regulations. The purpose of the NAIC law was to establish uniform or model terms, provisions, and wording standards for inclusion in all individual health insurance contracts. 12 Mandatory Policy Provisions. 1. Entire contract includes the actual policy and the application. It states that nothing outside of the contract includes the signed application and any attached policy riders can be considered part of the contract. It also assures the policy owner that no changes will be made to the contract or waive any of the provisions after it has been issued, even if the insurer makes policy changes that affect all policy sales in the future. This, however, does not prevent a mutually agreeable change or modifying the contract after it has been issued. Any change to a policy must be made with the approval of an executive officer of the insurance company, whose approval must be endorsed on the policy or attached in a rider. This mandatory health policy provision states that the policy, including endorsements and attached papers, constitutes the entire insurance contract between the parties. We can send you additional paperwork later. The entire policy and application is sent to you and that makes up your entire contract. Time limit on certain defenses. The time limit on certain defenses provision limits the time during which the insurance company may challenge the validity of an insurance claim based on a misstatement made on the insured's application. Under the time limit on certain defenses provision, the policy is incontestable after it has been in force a certain period of time, usually 2 years. This is similar to the incontestable clause in a life insurance policy. Unlike life policies, A fraudulent statement on a health insurance application is grounds for contest at any time, unless the policy is guaranteed renewable. An insurance company can usually contest the information contained in an accident and health application starting on the date the insurance company dates a policy. There is a time limit for which you must defend yourself. This applies to the contestable period, application, pre-existing conditions, and new claims, conditions that must be met while a claim is pending. If you file a claim that you broke your leg yesterday, and the insurance company sees you moving a grand piano up 5 flights of stairs, you will probably have to defend your claim. However, at some point, it is expected your leg will heal. 2. 47.3. Grace period. Purpose of the grace period is to give the policy owner additional time to pay overdue premiums. The policy owner is given a number of days after the premium due date during which time the premium payment may be delayed without penalty and the policy continues in force depending on the state. The minimum grace periods typically specified are 7 days for policies with weekly premium payments, that is, industrial policies, 10 days for policies with premiums payable on a monthly basis, and 31 days for policies payable on an annual basis. The effect of non-payment of premium before the expiration of a grace period will cause a policy lapse. If an insurer pays an individual accident and health insurance claim during a policy's grace period, the amount of unpaid premium may be subtracted from the reimbursement. Grace period is the same definition for your insurance bill as it is for all of your other bills. Don't pick it as an answer if the question isn't talking about paying your bill late and keeping your insurance. Remember Aunt Grace's birthday. 7 makes payments more than once a month, weekly. 10 makes premium payments once a month. 31 makes premium payments less than monthly, quarterly, semi-annually, etc. 7.10-31 Reinstatement. Reinstatement provision specifies that if an insured fails to pay a renewal premium within the time granted but the insurer subsequently accepts the premium, coverage may be restored. Under certain conditions, a policy that has lapsed may be reinstated. Reinstatement is automatic if the delinquent premium is accepted by the company or its authorized agent and the company does not require an application for reinstatement. If it takes no action on the application for 45 days, the policy is reinstated automatically. To protect the company against adverse selection, losses resulting from sickness are covered only if the sickness occurs at least 10 days after the reinstatement date. Accidents are covered immediately upon reinstatement. To reinstate any policy, you need a reinstatement application, statement of good health, all back premiums. Notice of claim. Notice of claim provision describes the policy owner's obligation to notify the insurance company of a claim in a reasonable period of time. Typically, the period is 20 days after the occurrence or a commencement of the loss, or as soon thereafter as is reasonably possible. You need to let the insurance company know that you are going to be filing a claim, so they are expecting your claim forms. Claim forms. It is the company's responsibility to supply a claim form to an insured within 15 days after receiving notice of claim. If the insurance company fails to send out the claim forms within the time period required by the provision, the insured should submit the claim in any form, which must be accepted by the company as adequate proof of loss. 4. 5. 6. 48.7. Proof of loss statement that an insured must give an insurance company to show that a loss actually occurred as a proof of loss after a loss occurs, or after the company becomes liable for periodic payments. For example, disability income benefits. The claimant has 90 days in which to submit proof of loss. Insurance company can't pay you if you don't prove there is a loss. Time of payment of claims. Time of payment of claims provision provides for immediate payment of the claim after the insurer receives notification and proof of loss. If the claim involves disability income payments, they must be paid at least monthly, if not at more frequent intervals specified in the policy. The purpose of the time of payment of claims provision is to prevent the insurance company from delaying claim payments. You did your part, paid your bill and got injured, sick, etc. Now the insurance company has to immediately do our part, pay you, and it can't be less often than monthly, or you wouldn't be able to pay your bills. Payment of claims. Payment of claims provision in a health insurance contract specifies how and to whom claim payments are to be made. Payments for loss of life are to be made to the designated beneficiary. If no beneficiary has been named, death proceeds are to be paid to the deceased insured's estate. Claims other than death benefits are to be paid to the insured. Should the insurance company pay you, or the doctor, or someone else? Physical exam and autopsy. The physical exam and autopsy provision entitles a company, at its own expense, to make physical examinations of the insured at reasonable intervals during the period of a claim, unless it's forbidden by state law. Forget everything you learned on Law and Order, only the state can forbid an autopsy. You gave up your and your family's rights to refuse when you applied for insurance. Legal actions. The insured cannot take legal action against the company in a claim dispute until after 60 days from the time the insured submits proof of loss. The legal action provision in a health contract is limited to no more than 5 years. The legal action provision provides the insurer adequate time to research a claim. At least give the insurance company 2 months to take care of you before you take them to court. Change of beneficiary. You can submit your claim using a napkin and crayon as long as you provide all the necessary information. 8. Group of dots. 9. 10.11. 12. The insured, as policy owner, may change the beneficiary designation at any time unless a beneficiary has been named irrevocably. 4911 Optional Provisions 1.2. Change of occupation. This provision also allows the insurer to reduce the maximum benefit payable under the policy if the insured switches to a more hazardous occupation, or to reduce the premium rate charged if the insured changes to a less hazardous occupation. Misstatement of age. The misstatement of age provision allows the insurer to adjust the benefit payable if the age of the insured was misstated when application for the policy was made. The insurer can adjust the benefit to what the premiums paid would have purchased at the insured's actual age. If the insured was older at the time of application than is shown in the policy, benefits would be reduced accordingly. The reverse would be true if the insured were younger than listed in the application. Other insurance with this insurer. 3, 4, 5, 6. Under this provision, the total amount of coverage to be underwritten by a company for one person is restricted to a specified maximum amount, regardless of the number of policies issued. This provision is designed to protect the insurer by controlling over-insurance through its own policies. Insurance with other insurer. In attempting to deal with the potential problem of over-insurance, the insurance with other insurer provision states that benefits payable for expenses incurred will be prorated in cases where the company accepted the risk without being notified of other existing coverage for the same risk. Insurance with other insurers. Similar to the previous, the insurance with other insurers provision allows an insurer to pay benefits to the insured on a pro rata basis when the insurer was not notified prior to the claim that the insured has other health coverage. Relation of earnings to insurance. If disability income benefits from all disability income policies for the same loss exceed the insured's monthly earnings at the time of disability, the relation of earnings provision states that the insurer is liable only for that proportionate amount of benefits as the insured's earnings bear to the total benefits under all such coverage. 57. Unpaid premiums. 8. Cancellation. Though prohibited in a number of states, the provision for cancellation gives the company the right to cancel the policy at any time with 45 days written notice to the insured. This notice must also be given when the insurer refuses to renew a policy or change the premium rates. If the cancellation is for non-payment of premium, the insurer must give 10 days written notice to the insured, unless the premiums are due monthly or more frequently. The cancellation provision also allows the insured to cancel the policy any time after the policy's original term has expired by notifying the insurer and writing conformity with state statutes. If there is an unpaid premium at the time a claim becomes payable, the amount of the premium is to be deducted from the sum payable to the insured or beneficiary. September 10, 2011. Any policy provision that is in conflict with state statutes in the state where the insured lives at the time the policy is issued is automatically amended to conform with the minimum statutory requirements. Illegal occupation. The illegal occupation provision specifies that the insurer is not liable for losses attributed to the insured's being connected with a felony or participation in any illegal occupation. Intoxicants and narcotics. The insurer is not liable for any loss attributed to the insured while intoxicated or under the influence of narcotics. Losses due to injuries sustained while committing a felony, or attempting to do so, also may be excluded. Other health insurance policy provisions and riders. Filing and approval of policy forms. Accident and health insurance policies must be issued and approved by the Commissioner. If the Commissioner does not reject the policy within 90 days, it is considered approved as is. Insurers may request a hearing within 20 days if their policy is rejected. The policy facet. Policy face contains a summary of the type of policy and the coverage provided by the policy. It identifies the insured, the term of the policy, the effective date and termination date, and how the policy can be renewed. Insuring clause. The insuring clause is a part of the health insurance policy that states the kind of benefits provided and the circumstances under which they will be paid. The purpose of the insuring clause in a health and accident policy is to specify the scope and limits of 51 the coverage provided. The insuring clause is a part of the health insurance policy that identifies the specific type of benefits or healthcare services that are covered by that policy and the circumstances under which they will be paid. Any promises the insurer makes will be in the insuring clause.